Again, if he does accept the property, it is subject to the mortgage, any other liens, or any other interest that the property was subject to at the time of the owner's death. Mechanics liens, tax liens, etc. It's still subject to those. Those still will have to be paid off. Just like if we had left it through probate, it would be subject to all of those debts as well, and those would have to be paid before the deed would be conveyed into the name of the beneficiary. Yeah. It does. TODI does not trump joint tenancy or tenancy by the entirety. But if a property is owned in joint tenancy or tenancy by the entirety, it doesn't preclude the owner or owners from drafting a TODI. But what would happen is it would only fall to the beneficiary after the last joint tenant or spouse, in the case of tenancy by the entirety, passed away. So if husband and wife own the property and they want to do a TODI leaving it to their son, it would go from spouse A to spouse B. Upon the death of spouse B, it would go to son. That's when the TODI would be effective. If they don't want it to be effective that way, then they need to deal with the joint tenancy situation while they're both still alive. Yeah.
So I don't want the property to go to my son, but my husband executes a TODI. He predeceases me. I get it.
Yes.
And is there anything I can do to prevent him from getting it, my son from getting it, or am I bound by that TODI that he executed?
No. You're not bound by it because you didn't execute it. Essentially, the TODI goes away because he predeceased you.
Uh-huh.
Now, I would probably recommend as sole owner of the property, and you absolutely don't want your son to have an interest through the TODI, then you'd want to record a revocation.
Okay.
At that point.
So when you're talking about...
Now, if you then passed away the next day, he would get it by intestate succession, or at least a portion of it, but that's a different story. But if, in the scenario that you said, where your spouse records the TODI that says, I want my interest to go to my son, the joint tenancy or tenancy by the entirety, however you and your spouse own property, would trump that.
Okay.
If, on the other hand, your spouse owned the property solely and said, I want the property to go to my son, and records the TODI, then the son would get it. Because the TODI trumps intestate succession, but not joint tenancy or tenancy by the entirety. Okay.
So you're talking about does not trump joint tenancy. You're thinking more about where people jointly execute one, husband and wife jointly execute a TODI
right.
for their son?
Okay. Or in the scenario that you said where the property is owned jointly and one spouse executes the TODI. We've run into that a couple of times, and so we sit down with our clients and we say, if you do this, it's still going to go to the spouse first or the other joint tenant first. And we want to make sure that they're aware of that the TODI is only effective essentially if the other joint tenant predeceases.
Right.
Unless they both sign off on it, yeah.
I thought a joint tenancy can be broken and creates a TIC, a tenants in common, if you execute something giving up your interest.
Right, but this is not giving up your interest. This is a this is a future beneficial interest only. If you, changing the hypothetical slightly, husband and wife own the property, husband deeds his interest to son now, that would break the joint tenancy. If it was in tenancy by the entirety and husband deeded his interest to son, that would be a void transaction. Right. That would have no effect whatsoever. But if one joint tenant deeds their interest, that breaks the joint tenancy and creates a tenancy in common between the new owner and the former joint tenant. This does not do that because it's a beneficial interest only.
Okay.
But I'm glad that you brought that up because that's a really important consideration. Yeah.
So can joint tenants or tenants by the entirety sign a TODI together?
Yes.
To grant?
Yeah, and the way that it's written is it will say, upon the death of the last joint tenant or the survivor of us, in the case of tenancy by the entirety, then it goes to whomever, the beneficial interest. That's very common.